Hi everyone, we're testing the audio. If you can hear the audio at this point, can you please enter it into your chat function so we know you can hear? Oh good, you can hear us now. Okay, so I apologize for the tech delay. I'm going to start over, Helen, if that's okay, because I don't think anybody heard anything. What people told me is that they saw the slides advancing, but they didn't hear the actual introduction. So. Okay. I apologize for the technical difficulties. So welcome everyone to today's webinar. Just a few notes. We will be recording today's webinar, so you'll be able to access that link as well as the slides after the presentation. This webinar is for advocates and those interested in the subject. Is not intended for press purposes. And at this point, I'm going to turn it over to Helen Blank to do the presentation. Please note that you can submit questions through your chat function, and we will open the phone lines at the end of the presentation so we can have more of a conversation. All right, Helen, sorry about that.
Thanks. Here we go again. I'm happy to be here today and to be joined by my colleagues Karen Schulman at the National Women's Law Center and Christine Johnston-Staub from CLASP. Today's webinar is going to focus on the importance of supporting parents in low-wage jobs, the provisions in the CCDBG reauthorization that affect parents in low-wage jobs, strategies for taking advantage of these provisions to support child care providers serving parents in low-wage jobs, and other early care and education policies that can help parents in low-wage jobs. Remember, submit questions at any time in the chat box, and I hope we can have a conversation after. 1 in 5 working mothers of very young children aged 3 and under work in low-wage jobs. Individuals in low-wage jobs not only struggle with limited incomes, but often have unpredictable, irregular schedules and frequently must work at night, in the early morning, and or on the weekend. Difficult work schedules can pose problems for parents, not only in obtaining stable child care, but also in accessing child care assistance due to policies that are often structured for parents with standard work schedules. The new CCDBG law provides an opportunity for states to better meet the needs of parents in low-wage jobs with non-standard or irregular schedules. The law aims to improve the health and safety of children in care, enhance the quality of care, and make it easier for low and moderate income families to access child care assistance that supports stable and continuous care. The law includes a number of provisions that give states greater flexibility to adapt their policies for parents in low-wage jobs with difficult work schedules. States should take full advantage of this opportunity to increase access to child care assistance and expand the availability of child care options for these parents. States should also take care in implementing new requirements that they do not reduce access to options such as family, friend, and neighbor, which we call FFN care, that might be the best or only option for parents in low-wage jobs with non-standard schedules. Christine, now I'm going to turn this over to you.
Hi, this is Christine from the Center on Law and Social Policy, or CLASP. I am going to talk a little bit about provisions in the CCDBG law that focus on increasing the supply and quality of child care for parents with difficult work schedules. The law includes provisions that require states to build the capacity of child care for specific populations, including those families in need of care during non-traditional hours, which obviously includes a lot of families who are working in low-wage jobs. That provision can definitely help improve access for parents who work in those jobs and in the service sectors and in other settings. The law also specifically allows for differential payments to programs that offer care during non-traditional hours as one strategy for encouraging providers to make high-quality, non-traditional hour child care available, so they can pay a higher rate, which I'll go into a little bit more, for non-traditional hour care. There are a number of ways that states can take advantage of the opportunities under these provisions of the law. One way to implement differential payments is through direct contracts or grants to providers who are offering non-traditional hour care. States can contract in specific geographic areas where there's a high need for non-traditional hour care, which requires data about the workforce and employment opportunities. or they can offer contracts more generally as an incentive for programs to offer those services during non-traditional hours. The benefit of contracts include that they offer more stability to providers who may hesitate to offer non-traditional hour childcare if they're not sure that the market for those services is there. And more stable providers also offer more continuity to children and to families. As the slide says, states can also use contracts to extend the day or the year of part-day, part-year programs like Head Start or pre-K, and that enables children access to those high-quality experiences despite their parents' non-traditional schedules. So while they might get child care for non-traditional hours while the parents are working, it might also allow for the child to participate in a Head Start or pre-K program that's during more traditional hours. In addition to a more stable income stream, a differentiated payment rate can help make offering non-traditional hour care or meeting families' varying schedules more appealing to providers for whom those arrangements may otherwise be less predictable in terms of revenue and more complicated in terms of billing the state for subsidy reimbursement. Differential rates may also just make non-traditional hours more feasible for providers who may have to offer extended hours and hire qualified caregiving staff who are willing to work during those hours and may have complications of their own. Some other strategies for improving both the supply and the quality of non-traditional hour care include technical assistance targeted specifically to providers, additional financial resources targeted to quality improvement, and efforts specifically aimed at the population of license-exempt family, friend, and neighbor caregivers, or FFN, as Helen said, including both coaching and training and concrete materials to help boost the quality of care. In addition to building capacity that meets the scheduling needs of low-wage workers, the CCDBG reauthorization includes provisions that improve access to subsidies and continuity of care for them and their children. For example, the law says that once a child's been determined eligible for child care assistance, states must consider the child eligible for a minimum of 12 months, regardless of temporary changes in a parent's work, education, or training activities, or family income, as long as the income doesn't exceed the 85% of state median income, which is the cap for at the federal level. So that evens out the experience for families who may have varying schedules week by week or month to month or even day to day. States must describe how their redetermination procedures and policies don't require working parents, and in particular parents receiving TANF, to disrupt employment in order to comply. And states must demonstrate how they'll take into account irregular fluctuations in parents' earnings when determining and redetermining eligibility. To help offer better access to low-wage workers and their children, states can ease reporting requirements of state subsidy systems, which are often a barrier to families keeping their subsidy over time. This is particularly a barrier for workers with irregular schedules, as many states right now require individuals to report any changes in schedules, changes in numbers of hours that they're working, or changes in income. If that's happening regularly or frequently, it makes maintaining a child care subsidy very challenging for the family. Although the law doesn't specifically say anything about reporting requirements, its 12-month eligibility provision makes reporting requirements less necessary. So because a family is eligible for 12 months, they may not be required to report changes as frequently or at all until the end of the eligibility period. Similarly, the law encourages states to simplify subsidy redetermination or renewal requirements at the end of that 12-month period and ensure that they don't disrupt parents' employment. With complicated or inaccessible redetermination processes, many families currently lose their subsidies even when they're still eligible. That causes a burden on the eligible family, who often either goes through the process to get a new subsidy or in some cases has to go on a wait list depending on the state. And it also adds additional administrative costs for states. Some state policies that can make redetermination easier include adopting policies and processes for determining eligibility that allow parents to renew their eligibility online or by phone, offering services during extended business hours for eligibility redetermination, or giving parents a long time frame during which they can renew eligibility so they don't immediately lose their subsidy but have some period of some grace period of time. Finally, changing the way states collect parents' income information for eligibility purposes can help improve their access to child care assistance. This can be particularly an issue for low-wage workers as their hours and income shift regularly. So getting an accurate picture of income for both eligibility at the beginning of a subsidy period and co-payment purposes is challenging. Some strategies states can use include averaging out a parent's income over an extended period of time, requesting representative paychecks rather than the most recent paychecks, disregarding temporary income, or taking other steps so that the parents are not deemed ineligible for assistance simply because their income rises for a week or for a short period of time. And I'm going to turn it over to Karen Schulman.
Thanks. So I'm going to talk a little bit about improving payment practices and what the law now requires and how it might provide an opportunity to make the practices work a little bit better for the parents with these difficult work schedules and the providers who serve them. The law says that states must implement, to the extent practicable, enrollment and eligibility policies that delink provider reimbursement rates from an eligible child's occasional absences. It also says that states must certify that payment practices for providers receiving CCDBG assistance reflect generally accepted payment practices for providers serving children who do not receive CCDBG assistance. We know that the policies under CCDBG in paying providers work very differently than they do in the private marketplace, where usually parents will pay a set fee for if they're attending for a certain number of days per month, and the payment isn't advanced. And we know that doesn't happen for the payment process in the child care assistance program. So this law provides an opportunity for states to look at how they can move these policies in the CCDBG program a little bit closer to how they look in the private marketplace, so that providers will be a little bit more willing to serve these families, particularly families who are receiving assistance and have parents working these difficult schedules. So here are some things that states can do in response to the law. They can pay providers for absent days or based on a child's enrollment rather than attendance. Practices that match those in the private sector enable providers to have more predictable income, making it more likely that providers will agree to serve families receiving child care assistance. And these policies can particularly help increase providers' willingness to serve families with parents working non-standard hours, since the providers will be assured of payment even if a child's attendance varies with his or her parent's work schedule. And it also makes it more likely that the provider will hold a slot for a child even if the parent works an erratic schedule. And so that provides more stability to the child, which is so important to their development and learning. So there are also some other ways in which payment practices can work better for providers and the families they serve. States can pay providers using the time units employed by the provider. Many states pay, by day or by week, or even a couple pay by hour based on the parent's work schedule and when they assume they'll need child care, rather than as typical in the private sector where there's just a flat monthly fee. So, states can look at paying using the time units employed by the provider. If the provider is charging its private paying parents by month, then it should be charging its CCDBG families by month. This approach is particularly helpful for these parents whose work hours might fluctuate from week to week or day to day. This allows the child to be in child care on a more stable basis. So now I'm going to move on to talking about the new requirements for child care around some health and safety provisions. The law has a number of new requirements that applies broadly to providers receiving CCDBG funds. So the law says that states must conduct a pre-licensing inspection and unannounced annual inspection for all regulated and licensed providers receiving CCDBG funds, and one annual inspection for license-exempt providers, except providers related to all children in their care receiving CCDBG funds. The law also requires that states ensure that providers, including license-exempt providers receiving CCDBG funds, complete minimum pre-service or orientation health and safety training, as well as ongoing training. And third, states must require all employees of child care providers, all licensed, regulated, registered child care providers, as well as all license-exempt providers receiving CCDBG funds, except for relative providers, to undergo comprehensive criminal background checks prior to employment and to maintain employment. Now, obviously, these create a lot of new demands on states. For some states, it might be a bigger stretch than others. Some states are doing at least most of this already, and some states are only, requiring some training or some annual inspections for certain types of providers and not for others. Some may be requiring some criminal background checks, but not the full set of 5 required checks under the law. So some states will have a lot of work to do and also a lot of new costs. And our concern is, as states face these new costs, they're going to look at, how to do it the most effectively with the resources they have, and they might look at, they might be closer to meeting the requirements for centers and licensed family child care, and they have further to go on the license-exempt providers. And our concern is that they might decide to limit the use of license-exempt providers. And the issue with that is as Helen said earlier, is that for many families, particularly those working these non-standard hours, license-exempt care is their best option or their only option. So we need to make sure that parents have decent options. We'd like to see more licensed family child care, more licensed centers available to these parents, regardless of their work schedules, but we know that there will still be a need for license-exempt providers. So it's important that as states implement the law, that they are ensuring that they are making efforts to make it feasible for all types of providers to comply with the new requirements. So here are some of the things that states can do as they implement the law to make sure it is working for the providers and the families. They should provide support for license-exempt providers through the annual inspection process. We'd like to see them use inspections not as an enforcement mechanism, but as an opportunity to offer technical assistance and resources, such as fire extinguishers, child safety plugs, smoke detectors, and other supply to help meet standards, and other educational materials for children and providers to improve the health, safety, and quality of care of these providers. And we'd like to see this and them using it rather as a sort of mechanism to punish providers as an opportunity to really improve the quality of all providers, including license-exempt providers. And we've seen this in some instances. We know that New York has tried to reach out, has tried to use licensing visits as an opportunity to provide some resources and support to license-exempt providers. So those are the annual inspection requirements, and there are also new training requirements, as I mentioned. And it's important that states try to make the training easily accessible to all types of providers. This would involve making training opportunities accessible for providers through many avenues, both online and community-based, and they should be affordable. Training should be offered in multiple languages. And providers should be permitted to complete the training shortly after they begin caring for children during an orientation period. The law does allow the training to be completed during an orientation period. It doesn't necessarily have to be completed entirely before they begin caring for children. And this is important. This allows some flexibility for providers to meet the needs of parents with unpredictable work schedules who may have a sudden immediate need for child care. On the new background check requirements, it's also similarly important to make it feasible for all providers to be able to actually comply with undergoing these background checks, and that the process is fair and doesn't unduly burden them. Under the law, states are permitted to charge providers a fee for costs associated with processing applications and administering a criminal background check, but they're prohibited from charging more than the actual cost to the state. States must complete a background check within 45 days of the request for the check, and they must have policies and procedures in place for individuals to appeal the findings of the criminal background check. And so now I'm going to turn it back to Helen to talk about some other ways that other types of child care policies that can support parents in low-wage jobs.
Well, if that wasn't enough to have on your plate, there's some other things that states can do and advocates can encourage them to do to support parents in low-wage jobs. We know going to school is important, and they can allow parents to receive child care assistance to attend school without imposing burdensome work requirements or other limitations. All 3 states only allow parents to receive child care assistance to attend school in limited circumstances. 2 states give this decision to localities. 19 states require parents to participate in school and or work-related activities for a minimum number of hours to be eligible for child care assistance. 11 states require at least some parents in school to also work for a minimum number of hours to be eligible for child care assistance, and those can be pretty considerable. 17 states limit the amount of time parents can receive child care assistance to attend school, so it limits their upward mobility. 35 states limit the degree or educational level for parents receiving child care assistance to attend school, and 14 states require parents in school to make satisfactory progress to continue receiving child care assistance. On our website, we have a policy memo called Building Pathways, Creating Roadblocks, State Child Care Assistance Policies for Parents in School that Karen wrote that you can refer to help you out. States can allow parents child care assistance to cover sleep time for parents working overnight and to cover transportation time. We know often parents have to work a considerable distance from their child care program, or they need time to sleep. States have the option of allowing license-exempt providers serving families receiving CCDBG to participate in the Child and Adult Care Food Program. New York, Washington, Illinois, Oregon are some of the states that do this. New York, I don't know if they still do, but they used to allow parents to stay in CACFP for 1 year, allow programs. CACFP has incredible benefits. Not only do children receive nutritious meals and snacks, but providers get visited 3 times a year by a sponsor who can provide assistance to them. This is a really important program. And states have the option of letting CACFP in programs that are license exempt that get CCDBG. It's an opt-in provision. States can help parents in low-wage jobs access pre-kindergarten for their children. They can support pre-kindergarten options in these families' neighborhoods. That means getting pre-K in low-income neighborhoods, especially if it's universal, even if it's not, making sure that policies put pre-K programs where children are. They can provide transportation between pre-K and wraparound child care. Now, sometimes there's a bus that does that. In Wisconsin, some children can go from pre-K, and there's public transport. There's a bus that will take them to family child care or FFN. They can support FFN providers who care for children before and after the pre-K day. In Chicago, there is a small program that provides transportation. It can be a van from FFN and family child care providers for children enrolled to pre-K. And the children are in a 2.5-hour pre-K program. And they get transported back to FFN. On the 5th day, teachers in the preschool program support the FFN providers. States can conduct extensive outreach to encourage participation in pre-K. They can provide full-day reimbursement for child care when pre-kindergarten operates on a part-day schedule, or when the hours of the pre-kindergarten program fall outside of the parents' work hours. So if you have a 2.5 or a 4-hour pre-K program, child care programs should get the full reimbursement. Michigan only reimburses child care programs by the hour, very few states this, do this, but this discourages them to want to encourage children to use pre-K. They can support FFN providers, as we said, who care for children before or after the pre-kindergarten day and offer them technical assistance, even if it isn't the Chicago model. They could think about offering supports to FFN providers through home visiting programs. Parents and Teachers has a special curriculum designed for FFN providers. Moving forward, implementation of CCDBG's new law is going to be challenging. As you've heard, it's complex with many new requirements and time constraints. Seizing opportunities will require resources. Now is the time for budget advocacy at the federal and state level. We hope you joined our call yesterday about not only more money for early learning, but also eliminating the caps, which limit the amount of available discretionary funding for programs. It's time to make the case for funding FFN care, giving the number of mothers who are working in low-wage jobs for young children, as Karen and Christine talked about. There are many provisions which in this reauthorization that might encourage a state to move away from funding FFN care, but this care is really important to help mothers working. Without this care and without the support, family stress could grow considerably. You can explain to policymakers that child care assistance is key to helping mothers work. Mothers don't have much to fall back on now. Let us help. We're eager to work with you. What provisions are most challenging in your state? Please tell us. Tell us what information you need. We do have resources available. We've written Implementing the CCDBG Reauthorization, a guide for states. It has detailed information on provisions in the new CCDBG law. It has recommendations and cautions for states. It also has state-specific information on key provisions of the law, CCDBG funding, and children served. On our website and on CLASP, you can print out state-specific fact sheets about CCDBG implementation. We also have state-specific fact sheets on your key indices of your child care subsidy programs. As of last February, we'll have a new report this fall, late fall, on current state child care subsidy provisions. Again, all of this is available at www.nwlc.org and www.clasp.org/CCDBG. So please look at these materials and please let us know how we can be more helpful. And we hope to talk about any questions you might have.
Great. Thanks, Helen, and thanks to all of our presenters. At this point, we're going to open the floor for questions and answers. I'm going to go ahead and unmute all of the phone lines, but I ask that if you are not interested in asking a question, that you mute your own phone line or your mic and speakers so that we aren't getting a ton of feedback over the line. And while we're waiting for that, actually, we got a couple questions. You can also ask a question over the chat function, and we have a couple of, oh, everyone, please, I'm going through and unmuting the phone line, so if you can just mute yourself. So, Karen, there was a question that came in during your presentation. How are occasional absences defined?
It is not defined. It is up to states to define how generous their absent day policies will be. Currently, states vary wide. Most offer some absent days, but they vary widely in how many they do. So, states should really relook at that policy and see how closely it matches their the private practices. And we're encouraging states to be as generous as possible, and including even more generous allowances for the needs of children with special needs.
Another question that came in just for your presentation, Karen. Sorry, folks could just mute their. If you could just mute yourself, so we're getting some background noise. All right. I know it.
And we're going to ask again.
Okay, so I've just muted all the phone lines since we were getting a little bit of feedback. So if you do have questions, please just send them in over the chat function. The other question for you, Karen, how will states be held accountable to new regulation? Or for anyone, but that came in during your presentation.
As a first step, states are required to fill out their state plans by March of next year, March 2016. So that's the first indication. Different regulations have different implementation timelines, so check out our CCDBG reauthorization guide for that. And there are provisions. There are some allowances for waivers for allowing for extra time. There are also some provisions that for penalties on certain provisions if states are not complying. We don't know how exactly that would play out. So do you have anything to add, Helen or Christine?
Well, there never have been penalties, so that's interesting. There's a penalty provision, and I think it's up to 5% of a state's allocation. We hope we don't see this happening, and we know this is all challenging because many of these provisions are quite costly. So it's going to be important to be on top of all of this and to fight hard both at the federal and at the state level with your state legislators and your governors to demand increases in the next budget year for CCDBG, which will help with some of these.
I also think the Office of Child Care has signaled that they really want to work with states to make this work. So, in the state plan template, which isn't finalized yet, but in what looks like what the state plan template will be, there are a number of provisions where states can say, we're not in compliance with this yet, but here's our timeline and here's the steps we're taking to come into compliance. It's not available for all of them, but I think it's a recognition on the part of OCC that some of these provisions are going to be hard for states to meet, and so at the very least, states have to indicate that they have a solid plan and they know how they're going to meet them eventually.
And it's important for states to start acting now to think through the steps they need to get where they need to be, figure out, what are the barriers, what can you communicate to the Office of Child Care about the issues in implementing it, what can you find out from various stakeholders about what the issues are in implementing it and how it will go about. So the sooner the better you can start thinking about how to get this done rather than what happens if you don't.
We have another question that came in through the chat function saying, in the health and safety training requirements, are there any training funds for provider safety, such as ergonomics of family child care?
Well, there's no guaranteed funds. Just to answer the funds part, right? There's no guaranteed funds in the law at all. There is a required increase in the quality set aside, which can be used to help support providers in a number of ways through quality improvement systems or through grants, and for a number of activities. And I would think that seems to be something that could fall under the categories of uses of quality set-aside dollars. I just will emphasize, since we're talking about quality set-aside dollars, that's a set-aside that already exists, but it's going to, under the law, it expands over the next several years. And without additional investments, as Helen's been saying, the overall pie doesn't expand. So as the quality set-aside expands, there's going to be trade-offs. So that's just an important thing to think about with quality dollars. And a reason to continue advocating for more money overall, both on the federal and the state level.
The training requirements require training in 10 specific areas listed in the law, and they address areas such as first aid, emergency procedures, safe sleeping practices, but it's around the health and safety of the child. Now, there is nothing in the law that says the state couldn't include in its training requirements something about providers. So, and as we said, there's as Christine was saying, states can choose to use their quality dollars for additional training.
Thanks. And just as a reminder, because we've gotten a couple questions, we will circulate a link to the recording and the PowerPoint slides within the next few days, so you'll be able to reference and share those. Another question, is there coordination between CCDBG funding and the new WIOA, which requires workforce centers to serve more people with barriers to employment?
Well, that's such a good question. I was actually at a meeting that CLASP sponsored that had the WIA advocates, and in some ways the WIA law is sort of similar to CCDBG in that it is very greatly expanded without new money either. So I don't think there was a lot of thinking about coordination. I think there should have been. And we have been talking as part of another project about low-wage women and scheduling to a number of people working in workforce and one-stop shops. And, many of them find child care challenges as well, because really, when push comes to shove, unless you've raised a little special money, you're all dependent on CCDBG.
Yeah, I think it's an opportunity for states to think about how to work across agencies. Since the two processes are going on simultaneously, it makes sense at the very least to look at where there are opportunities for connection, and certainly where you'd want to avoid opportunities for conflicting implementation provisions. But so the opportunity is there. I think it will take leadership on the state, on this part of the states and the agency heads that are doing the implementation on the different pieces. And I would encourage everybody to look at the materials at National Women's Law Center, but also on the CLASP website around WIOA, and think about where those opportunities might be for collaboration.
The law requires collaboration with a whole list of programs and agencies. I don't know I don't think this program is one of them. But again, just because it's not required doesn't mean
right.
You can't make sure that they're part of the team as you develop the plan and come up with strategies.
Okay. We still have time for more questions, so if people have any last burning questions, please send them in through the chat function. While we're waiting, I guess, are there any additional thoughts from our presenters?
Yeah, I think it's important to understand, too, that the information that we're providing is based on what's in the law, what's in the drafts of the state plan template, and we expect additional guidance to continue to come out from the Office of Child Care. So please, stay in touch with us and follow our materials that we put out, and follow the Office of Child Care if you are working on this, so that you know as guidance comes out. And hopefully we'll have regulations, I don't know, by the end of the year, hopefully. But there's always a possibility that there will be more detailed guidance in the regulations and more detailed requirements.
And the regulations will come out for comment. And so once we see the regulations, we'll be doing proposed comments, and we want to hear from you what your reactions to the regulations as well. And we certainly think it's important, as an advocate for low-wage women, to get involved in the CCDBG process in your state. It can sound daunting, but if you're working for low-wage women, you have a significant constituency where child care is exceedingly important, and we want to make sure that those opportunities remain open, and that we build a stronger, more well-funded child care system through this process. We're happy that you joined us today. We thank you for all your work, and we urge you to stay in touch anytime with Karen, Christine, or myself. If you have questions, if you have comments, we're glad to help. And please look at the materials on our websites, and we'll keep producing materials. In addition, we're going to be creating a learning community for state child care advocates that'll have calls once a month to talk about implementation issues. So, and we'll be sending that out to our state list, and I think you're all on it. If you're not on our state advocates list, please contact me, hblank@nwlc.org, and we'll add you, but we'll let you know about those state learning sessions as well. They won't start until the fall.
Okay, thanks everyone. This concludes today's webinar.